Okay, we're being live streamed. And so I'm not used to this. I don't know how to use your mouse. How do I do this? How do I click it? Just take off. Right click. So right or left click. Okay. You could use this pad. Okay. So you'd rather use the pad. Yeah.
All right, good morning, everyone. We're here for the Monday, June 23rd, 2023 civil calendar for Judge Rachel Krause. It is a fairly short calendar. We have two default matters up first, and they are most likely what the judge will take first. And then we have a interpleader final hearing, and finally a motions hearing in the Calabrese matter. I do believe our court reporter will be joining us. If anyone is requested takedown, if you don't see her yet, she's coming, and I expect the judge to log on momentarily. Mr. Sams, you're here for the interpleader matter, I assume?
Yes, Mr. Freehoff, I am.
Okay, great. Has a proposed order been sent to us?
I believe there's a disagreement between the city of Atlanta and Mr. Long.
Oh, that's right. This is a continuation based on those fees. Yeah, okay. This was briefed. Okay, the judge will handle that then. All right. All right. In that case, like I said, the defaults will be up first, and then probably you, Mr. Sams, in the interpleader matter, and then we'll get to the Calabrese matter. All right. Hold 1 second.
Good morning.
Good morning.
Good morning.
Good morning. I have a few quick matters on for this morning, and then I have a couple that I think might take a little bit more time. I'm just going to call the calendar real quickly and figure out what the lay of the land is, and then we'll get started. Position 1, Unique Sports Products versus Marcia, is it Doss and John Doe's?
Hi, sorry, issues with my muting. Yes, Your Honor, Allison Ballard here for Plaintiff Unique Sports. We have a default motion that we filed last week, submitted a proposed order
Right,
as
I've
well.
reviewed it. I assume you've had no contact with and do not expect Ms. Doss or someone on her behalf to appear today.
That's correct, no contact.
Okay, thank you, Ms. Ballard. First Portfolio Ventures versus Cynthia Givens.
Hey, good morning, Your Honor. Luke Stuckey here for the plaintiff.
Okay.
Same, we have a motion for default judgment pending, and we submitted a proposed judgment to Mr. Freehoff.
Right, which I've also reviewed, and same question to you. I assume you've had not any contact with Ms. Givens and don't expect her or an attorney on her behalf to appear today.
That's correct. Yes, Your Honor.
Okay, thank you. First, Fulton County Sheriff Labatt versus Charlotte Roderick. This was, I remember, a reset. I see Mr. Sams here, who I think very appropriately does not have a dog in this fight. But the reason I had asked it to come back is there was a dispute between Ms. Roderick on the one hand and the city of Atlanta as to the amount of the lien asserted by the city of Atlanta, if I remember correctly, and I have reviewed the briefing that was submitted by the parties. How long do you think that will take for y'all to run through Mr. Long and Ms. Long Daniels?
Your Honor, good morning. I don't think that it should take any more than 10 or 15 minutes.
Okay.
I agree. It's a very straightforward analysis.
Okay. And did y'all ask for takedown?
No.
Okay. And okay, thank you. And then I have Jill Sigavus Calabrese versus Ann Sigavus Duncan. I apologize if I am mispronouncing that name.
Your Honor, Alex LaHorse for the respondent. Her name is Calabrese.
Okay.
I believe you got Sigafus right.
Okay.
And Miss Alexa Ross is representing move-in. She was on a few minutes ago.
And she popped off and then she's back here again. So
Okay, I've been popping on and off inadvertently too, and I
Yeah.
apologize.
hopefully our internet will stabilize here in a few minutes. Ms. Ross?
Hello, Your Honor. I represent Ann Sigafus Duncan. Duncan is really easy to pronounce.
Okay, and the motion that's before the court is the defendant's motion. I believe there's a motion for summary judgment, and then there's also a motion to dismiss an amended pleading. Is that correct?
Your Honor, if I
The
may.
latter is a motion to dismiss or strike portions of an amended pleading.
Okay, yes, Mr. LaVorse.
Oh, I was going to say, yes, Your Honor. Both motions were filed by the defendant. In this case, summary judgment and the motion to strike, which is being treated as a motion for summary judgment because there were matters outside the pleadings that were inserted into that motion.
Right. Well, this was previously scheduled for a summary judgment hearing, and then an amended complaint was filed that raised some new matters, and the parties advised the court, and so we moved the hearing date to today. And so right now, I understand you guys don't agree on much, having read your briefing. But right now, I'm wondering if you can agree on, did you request takedown? And what do you think the time announcement will be for this matter? Ms. Ross?
I'm sorry, you froze. I didn't hear anything after. Did you agree?
To take down? And how long do you think this will take in terms of your motion?
We did not agree to take down, but I'm fine with takedown. Alex, I assume you do as well. I think my portion will take 40 minutes.
Okay, Mr. LaVorse?
Your Honor, we did request a takedown. Ms. Taylor has agreed to take it down.
Well, I knew somebody requested takedown because Ms. Taylor was here, so that's why I was asking.
Yes, Your Honor. And for the motion for summary judgment, I would say 20 minutes. For the motion to strike or dismiss, about half that for the plaintiff's respondent side.
Okay.
My time, Your Honor, meant for both. I plan on addressing both motions together in 30 to 40 minutes.
Okay, well, I'm going to put down an hour. And here's what's going to happen. So the matters that are ahead of you are going to take about the next 20 minutes-ish for me to address. And so what I may be a little bit longer than that, given that the other matter, the one right before you, has got a little bit of meat on it. So Ms. Ross and Mr. LaVorse, what I'm going to do is excuse you until 10 o'clock if you want to go dark or disconnect or whatever, as long as you are reconnected and ready to go in front of your cameras at 10. And then I'll have Ms. Taylor will come back on and we'll take up that matter at that time. Okay.
Yes, thank you, Your Honor.
Okay. Thank you.
Thank you, Your Honor.
Okay. So circling back fully around to Ms. Ballard. So I looked at your default motion and everything seems in order, although for my personal benefit, I'm going to have you just walk me through the particulars. But I would like for you to specifically address for me the fact that your theory of venue, given that the defendant is in Washington, and the main, really the only concern that I had is the service seems to have been accomplished by personal service, but there seems to be an assertion in the service document that the servicer was specially appointed. Like the summons says, I'm specially appointed / Washington. I just want to make sure you and I are on the same page that if it's an out-of-state person, it's only got to be someone who is properly authorized in that state to perfect service. Are we in agreement on that issue?
Yes, Your Honor.
Okay. Then if you will just briefly walk me through date of service, theory of venue, date of service, and then we'll go from there. And what the relief is that's you're seeking in your default order.
Sure, absolutely. So this was internet wire theft that occurred in April of 2021. Unique Sports, my client, is a business here in Georgia. They communicate regularly with a supplier by the name of AP Tech that's located in Japan. Some individual, unknown, intercepted or gained access to Unique Sports's email system and used a fraudulent email address to misdirect a wire transfer that was going to the supplier and send it to this individual. It was a little over $180,000. The wire transfer was effectuated. We filed a complaint which is not this case, shortly after the theft in 2021, and against John Doe's. We're able to subpoena at this point both of the banks that were involved, the bank that initiated the transfer and then the bank that received the funds. Upon the information we collected from those two subpoenas, we were able to identify the account holder who received the money as Marcia Doss, this individual located in Washington. We did have her served. I think for venue, our theory is that she was, received a wire transfer from our client here located in Georgia, and presumably, intercepted our client's computer systems, which are located here in Georgia. That's our theory there. I wish I could speak more specifically to the affidavit of service and why it had that language in it, or the order, about the special appointment. I don't know. I can check with my paralegal on that. Unfortunately, my paralegal who did that is actually out of state at a trial right now. So I might not be able to get you that answer too promptly, but I agree with you that language is that is confusing, and I don't understand why it's there. In any event, we are only seeking a judgment on the principle. To be frank, we're not entirely sure about the collectability of this judgment. Internet fraud usually moves pretty quickly.
Right.
But so for that reason, to not burden the court and to simplify it, we are not requesting attorney's fees or punitive damages. We're just seeking a judgment on the principal amount that was received by that account holder.
Okay, so Ms. Ballard, I am looking at the proposed order that was submitted for position 1 today, and the total judgment that you had requested was that $186,854 even with post-judgment interest, and you have indicated you're not requesting attorney's fees or additional damages. It does appear that more than 30 days has passed, and in fact more than 45 has passed, such that Ms. Doss is in default. And so I will go ahead and enter the order that was submitted on behalf of Unique Sports. We'll get that on file for you guys today.
Great. Thank you, Your Honor. Is there anything else further? Or
no, that's it. You may be excused. Have a good day.
Thank you. You as well.
Thank you. Mr. Stuckey.
Yes, Your Honor. Good morning.
Good morning. So First Portfolio Ventures versus Cynthia Gibbons.
Yes, Your Honor. So this is a credit card matter. We are asking for the court to award the charge-off balance of $3,437.65. Ms. Gibbons was notoriously served on November the 13th of last year. No answer has been filed, and damages are liquidated. So I would ask that the court enter the proposed order that we submitted.
When you say notorious, give me a little bit more information about that, please. Yes,
Your Honor. So Michael Gibbons, the father of Cynthia Gibbons, was the one that was served. They were served at 3180 Park Court Southwest in Atlanta.
Okay, thank you for that follow-up. I appreciate that. And I am looking at your proposed default judgment, which is totals $3,437.65, and with costs of $264.
That's correct.
No attorney's fees. Is that correct?
That's correct. Yes.
Okay. Everything appears to be in order, Mr. Stuckey, so we'll go ahead and get it on file for you. Okay.
Thank you so much. That's it for me, if I may be excused.
Yes. Thank you. Have a good day.
Thank you. You too.
Okay. Mr. Long, Miss Long Daniels.
Let's see, who do you want to go from? Maybe Ms. Long Daniels to go or no?
Well, I am going to hear from Ms. Long Daniels, because here's what I understand, right? So basically, I just need y'all to educate me about your dueling interpretations of, is it 4129? As I understand it, nobody disputes that the city of Atlanta has a lien against some of the excess funds. that the dispute is about the amount of the excess fund, and that the real dispute is that the city imposed a very large penalty associated with demolition, if I remember correctly.
Your Honor.
The city has a lien in the amount, Your Honor. The principal amount is $16,855. And in addition to that, the city has assessed a penalty that's calculated at the rate of 1% per month from the date that the amount became due, which would have been the recording date.
Right, which is that 13,000, that very large penalty that I had.
Yes, Your Honor.
Okay, so if you'll walk me through, because I do think it makes sense to start with you because you are the claimant in the sense that you're claiming entitlement to that amount. And then I'll hear from Mr. Long on behalf of his client in terms of the challenge to the issue of the penalty. But I do want to make clear, Mr. Long, just to confirm, that your client is not challenging the $16,855, which was the principal amount. Is that correct?
That is correct.
Okay, so Ms. Daniels, Long Daniels, you can focus your efforts on the dispute regarding the fee.
Okay, thank you, Your Honor. Under the authority of OCGA 41-2-9, the city has implemented its own housing code. And the housing code is the code that we look to in terms of abating nuisances in various communities. 41-2-9 provides that the penalty shall be calculated at the same rate as a penalty would be calculated if you're imposing ad valorem taxes or collecting ad valorem taxes. 41-2-9 should be considered in concert with the city's housing code. So our position is that 41-2-9 specifically authorizes the city to collect the penalty, and that it also provides the method by which you would calculate it. Specifically, section 41-2-9B3 states that the unpaid lien shall bear interest and penalties from and after the date of final determination of cost in the same amount as applicable to interest and penalties on unpaid real property ad valorem taxes. That is the provision that we rely upon in terms of determining what penalty amount would apply. And in terms of how you calculate penalties on ad valorem taxes, then we would look to 48-5-24C1.
Okay, so if I understand the state's briefing and position correctly, so I don't think anybody disputes that the statutory structure allows the city to undertake to impose liens and to enforce those liens. But it sounds as if the parties are generally in agreement that in order to do that, the city has to do something. I think Mr. Long's client's position is that the city either hasn't done it or hasn't done it adequately. Setting that issue aside for the moment. If I understand the state's position correctly, it's that you are authorized to impose a lien and that the city handles those liens in the same manner they handle ad valorem taxes, and it's the ad valorem tax penalty that it's imposing. Is that right?
No.
Okay.
The penalty that's being imposed is on the demolition lien, but in terms of how you calculate the penalty, the statute states that you look to how the state calculates a penalty on ad valorem taxes. And then that specifically states that it shall be calculated at the rate of 1% per month.
Okay.
But it's just saying that that's the same type of calculation, or that's the method by which you calculate it. But they're totally separate and apart, the ad valorem and the demolition lien.
Okay, so here's where I get a little confused. I see that the lien includes that language, right? The lien includes language that says the unpaid lien bears statutory penalties and interest from and after the date of final determination of costs in the same amount applicable to interest and penalties on unpaid real property ad valorem taxes.
That is correct, Your Honor. It's stated on the face of the lien.
Is that statutory language that is being referred to in the lien? That's what I'm confused by.
It's tracking the language or the provision of 48-5-24C1.
Okay. Thank you, Ms. Long Daniels. I appreciate that. Okay, I'm probably going to come back and have questions again in a moment, but for now, unless you have anything specifically to add, I'm going to hear from Mr. Long, if that's okay.
That's fine, Your Honor. Thank you.
Thank you. Mr. Long?
Okay, Your Honor, thank you. If you read 41-2-9, A3. In the middle of that section, it reads as follows. If the officers investigate, this is talking about the appointed officer from the city, for example, who goes out and inspects and finds the problem. It says, if the officer's investigation or inspection identifies that any building, dwelling, building, structure, or property is unfit for human habitation and blah, blah, it goes on and on and on. The public officer may issue a complaint in rem against the lot, tract, or parcel of real property on which the dwelling, building, or structure is situated. And it goes on and on. It says the complaint shall identify the subject real property by appropriate street address, blah, blah, blah. And it goes on and on and on. If you look in my brief, footnote number 3 on page 4, quote your colleague, Judge Richardson, in another civil action that I found. And he says, and he found in that case, I know it's not binding authority, it's just, you know, it is what it is. He found in that case, it says, quote, ARI, which was the equivalent of Miss Roderick here in this case, also challenges the authority of the city to charge penalties on the principal amount of the demolition lien. The city cites 41-2-9B3 as the basis on which it is entitled to charge a penalty, quote, calculated at the rate of 1% per month, end quote. However, that statute applies to liens arising out of judicial in rem proceedings, not administrative in rem proceedings, the latter of which give rise to the city's lien in this case. So here, if you look at the city of Atlanta's ordinance, section, it's Appendix E, and it's entitled, I mean, the title of Article 3 of the city's ordinance, Article 3's title is, quote, administrative in rem. So Ms. Long Daniels in the city of Atlanta, I don't know why they don't amend their housing code, but the statute she's relying, the city, excuse me, not her, the city is relying upon is calls for a judicial in rem. This is an administrative in rem. Thus, 4129 is inapplicable. It doesn't even govern. So therefore, there is no statutory authority cited by the city of Atlanta that authorizes the city to charge a penalty. My brief goes into some other code sections, and it goes into some other, I didn't do a great job in my brief. I go back and reread it and I criticize myself. Some of my analysis is under the presumption that 4129 applies and it's applicable, but it's not, and it does not apply. So therefore, these other code sections relied upon to calculate interest and the like don't apply either. And plus, none of these code sections, I articulate this in my brief, none of these code sections articulate penalties. They articulate interest, not penalties. There's no, in Georgia law, I looked through the black letter law of Georgia law code, does not impose a general applicable penalty rate across the board, like the state statutes do with respect to interest rates. Interest rates are oftentimes prime plus 3% and the like. And so it's a pretty universal standard for the applicable interest rate application to judgments and liens and things of this nature. There is no penalty rate. There are only specific penalties applied to specific types of taxes in the state of Georgia. A demolition lien is not a tax. And so you can't apply the interest rate applied to a tax to a demolition lien. And I articulate this in my legal brief. So on many levels, the city of Atlanta does not have the authority to not only charge a penalty, even if they did, the statutes they cite do not charge a specific penalty rate. They charge an interest rate on certain types of taxes that are unpaid, but they don't apply to demolition liens, which are not taxes. So with that said, that's the crux of the legal issue that Ms. Roderick brings to the city of Atlanta's attempt to try to impose a penalty. We don't have a problem with the underlying tax on the, I mean, if you read here, section 37, I don't mean to be long-winded, but section 37 of the city's ordinance, it's pretty short. And this defines what the lien can be for. It says the amount of the cost of such vacating and closing or demolition of cost of vacating and closing or demolition by the city and the filing by the director of an itemized statement of the total sum of said cost in the applicable county lien document, end quote. There's no provision for the lien to include any kind of a penalty. It's just the raw hard cost the city incurs in demolishing a structure. Here, it turned out to be a little over $16,000, almost $17,000. We don't dispute that. So with that said, Your Honor, that's the crux of our argument.
Okay. Ms. Long Daniels, I wanted to give you an opportunity to respond to the other case he's referring to. And as I understand it, the basis of that argument is basically that the statute that the city is relying on is one that authorizes liens to be imposed in judicial proceedings, and that this is that the lien itself, this is a judicial proceeding, but that the lien that was imposed and the demolition that was undertaken is administrative and not judicial in nature.
With respect to the opinion that was entered by Judge Richardson, with all due respect, I disagree with the opinion. I don't think that there's a distinction between judicial and administrative in rem in terms of applying 41-2-9. It states that in addition to the provisions in that statute, a municipality can enact its own ordinance, which would also, in addition to the state statute, govern how you proceed with liens and the collection of the principal amount and the penalty. It's not logical that the city would have a provision that allows for the collection of the amount that the city expends in demolitions without any interest or penalties being calculated. The city, in enacting its ordinance, relied on the statute, the state statute 41-9, in determining the city's penalty amount and how you would calculate that amount. So I don't think you can look at them separately and independently. As the authorizing statute, I think that we can look to that in terms of determining how a penalty is calculated. And that's what the city relies upon, Your Honor.
Okay. Well, I appreciate both of your positions. I have reviewed your briefing. Mr. Sams, as I said at the beginning of this hearing, I assume you don't have a dog in this fight and you're just here because, you know, you're waiting to see what to do with the money. Is that right?
Actually, Your Honor, I think I've been excused and I didn't
I
realize
thought so.
that.
I
Yeah,
thought that I had said I would let everybody out except the two parties that were dueling. So,
you absolutely did, and I showed up anyway.
well, thank you, Mr. Sams. Your presence is always welcome.
Thank you.
I want to I've read the briefs. I'm aware of what the basic issue is, but if I'm going to issue an order that either agrees with or disagrees with one of my colleagues on what is a similar issue, I want to spend a little bit more time stewing on it before I say one way or the other. And I definitely think that I need to spend, because I mean, here's my issue. I agree with Ms. Long Daniels that the housing code isn't perfect, but it probably gets you where most of the way of where the city wants to be, assuming that the initial enabling statute is the applicable one. And that's really what I've got to start with and figure out. And so that's what I'm going to spend some time with. And then I will get you guys a ruling. What will likely happen is you'll just get an email from Mr. Freehoff that says the court has said XYZ. Somebody please prepare an order. And then my goal is to have that to you no later than the end of this week, hopefully sooner, since today is fresh new week of Monday, but we'll see. Any questions or anything else before I excuse you guys?
Not for me, Your Honor.
No.
Okay. Thank you both.
Thank you.
Have a good day. Thank you, Mr. Sams. And for those of you who are here for the 10 o'clock, we're right on time, except I'm going to take about not 5 minutes, maybe 3 minutes to get some fresh coffee, and then we will get started.
Thank you, Your Honor.
Ms. Ross, did I hear you say you wanted to participate in takedown?
Yes, please.
Can you send me your email? I don't know if I have it before, but
Want me to just tell it to you or send it to you?
you can send it to me
Okay.
in the chat. Thank you so much.
Hi there. I have minimized this whole screen and don't know how to make it large again. Is anybody a technological genius there who can tell me? Nobody?
And there a little box that you can click on.
Yeah, I've been clicking the box. Oh, look, it gets smaller and smaller.
Well, you're pretty big. If it helps, you're pretty big on my screen right now, Alexa.
You're all very little on my screen.
Well,
Do you see a little
so
box
kind
that
of you to
says
say that.
view on the top right-hand corner?
Yeah, that's what I've been. Top
When
right.
you click that, what happens?
Oh, on top left I have. I don't have anything on the top right.
Nothing that says view?
No, don't stay. All right, you know what? I'm gonna resume. Let's see if I can do this. Bam. Well, that's me. I gotta get everybody else. I'm gonna write share screen. Click on participant. Can't believe I did this. Share screen. Oh yeah, okay, no. No, that's sharing your screen. Okay. Oh, it's right here. Video. Video settings. Great. Screen.
For what it's worth, Alexa, you're mute.
That is on purpose. All right. I think Alex and I can be seen, and I guess I just. Oh, you know why? It's only you and me, because everyone else has the camera off. I believe Judge Krause now does.
I'm back.
All righty. I think we're good. I am not muted, right?
Okay. Ms. Taylor, are you ready?
Yes, I am, Judge.
Okay, this is going to be a hearing on summary judgments in the matter of Jill Sigafus Calabrese. Is that right?
That's very close, Your Honor. Calabrese.
Calabrese, thank you. Versus Ann Sigafus Duncan, individually, and is the executor of the estate of Corinne Baldwin Sigafus. Case number 2021 CV 345576. So Ms. Ross, this is your motion. Before you get started, I'm going to tell you what I understand to be the primary issue, or what I understand broad strokes of the case, so that hopefully you can omit things that you don't need to explain to me if I already understand them correctly, or you can correct me if I have an incorrect understanding of what you believe is important or relevant about the case. So Ms. Calabrese and Duncan are sisters. When their mother passed, Ms. Sigafus had a will that was probated in 2018 in Fulton County, and Ms. Duncan was named the executor. There was initially, and that seems to be what was the subject of the original lawsuit. There was a dispute over a payment or attempt to make payment to a third party. And then there was a dispute over some rings that are still in the possession of Ms. Duncan, and Ms. Calabrese asserts that they belonged to her and were not estate property. But even if they are estate property, she's entitled to them, and that Ms. Duncan has converted them by continuing to retain them. And that Ms. Duncan has breached a fiduciary obligation as executor of the estate in terms of payment or alleged effort to make payment to this third party. So then there was an amended complaint that was filed that I believe, as I understand it, really injected two things. One is there seems to be an understanding now that the $50,000 payment that was challenged was never actually made. And so now it seems as if the focus of the breach of fiduciary duty obligation is more on the use of estate funds for unnecessary attorney's fees and other expenses. We've still got the rings associated with the conversion claim. I am aware, yes, that there's a punitive damages claim and an attorney's fees claim. And then there now is, and this is the part where I get a little hazy, is an issue associated with property that belonged to Helen May, who I believe to understand is the deceased former mother-in-law of the deceased Corinne Sigafus, maybe. But the reason I'm confused is not necessarily because of who she is. It's because I was confused about whether the parties were asserting that that was estate property or non-estate property. And so I wasn't clear if it was associated with the conversion claim, as in you've converted property that belongs to me, or it's estate property and you haven't disposed of it properly, and therefore it is associated with the breach of fiduciary duty claim. So that's the universe of knowledge that I think I have. And if I've got anything wrong, please correct me. And if you can use that as sort of a guide to focus on the parts where there is disagreement and there is something that the court needs to address. Ms. Ross, it's your motion, so if you'll go ahead.
Thank you, Your Honor. Your Honor, the claims here are simple and they are small. There are two claims, two substantive claims. The conversion claim seeks two rings that Ms. Calabrese says are hers and that she should get them outside of the estate. And the breach of fiduciary duty claim seeks $6,651 in fees that the estate paid to estate counsel, as Your Honor said. Now, there are very few facts relevant to these claims. And one of the most important things I want to start out with, because I think it's going to make this a whole lot shorter, is that the undisputed evidence of record shows that before the complaint was filed, Ms. Duncan had at least twice offered Ms. Calabrese the rings outside the estate and asked for proper mailing information with no.
To that point, Ms. Ross, tell me what you mean by outside the estate, because as I understand Ms. Calabrese's position is that there were always strings attached, that it was not an unequivocal offer of return, and that it was typically associated with sacrificing some other claim associated with the estate.
Thank you, Your Honor. There are several exhibits. One is Plaintiff's 21 that answers your question. This letter is the letter that was the closest in time from defense counsel to plaintiff's counsel regarding these issues, okay? And it says, Ms. Duncan will give Ms. Calabrese both of the rings as requested outside of the estate. Your client will receive not 50% of the value of those rings, but all of the rings. Now, then the letter goes on to talk about the remainder of the estate. Please, before it does that, it says, please provide us with the address and preferred manner of delivery. That same offer was made on September 24th by estate counsel. And this is Plaintiff's 15. As it relates to the two rings, Ms. Calabrese will receive both rings per her request. We ask that you please provide us with the manner in which delivery shall be made and the proper address.
And what are the dates on those offers, Ms. Ross?
September 24th, 2020 and December 15th, 2020. The complaint was filed in February 2021. I want to be clear, Your Honor, that there was an October 2020 letter that offered the rings as part of the estate. I didn't write it. It seems to have been an error, but there's no doubt that the.
Well, in fairness, my concern is not really that they're offered as part of the estate or not part of the estate. It's more, are they being offered as a chip in a settlement negotiation? And I don't mean for purposes of whether they're admissible or not, settlement negotiations. I mean, as in, here, we'll give you the rings, but you have to agree to resolve all these estate disputes. That's really, whether it's estate or non-estate, that's really my issue, my
Absolutely,
question.
yeah, absolutely not. If you look at the letters, December 15th, P21, and September 4th, P15, both of those letters state she can have the rings out as though they are her property. Please send us an address. Then we talk about the estate. Nowhere in these letters does it say we have to settle everything. There wasn't even a lawsuit filed yet, right? And so nowhere does it say that. Now, the rings, okay, so that's the conversion claim. Okay, now, the breach of fiduciary duty claim is limited to $6,651. And Your Honor, I was going to read provisions of the will, but it seems to me like you're pretty up on that. The will, it's your standard will that says my executor has sole discretion to determine what is in the estate. Now, these are the undisputed facts that back up what Ms. Duncan did to identify the estate. Now, and there is absolutely no evidence to the contrary on any of these items. Nani is the name that
Right. I saw that in the briefs.
she lived with Ann and Dee Duncan for over 25 years, never paid to live there. She's part of the family. You know, they ate breakfast together, had lunch together. They were a family. Plaintiff is estranged from most of the family. She was
Well,
estranged.
let me save you some time, Ms. Ross, because I mean, I did read your briefs. I mean, I really did. And as I understand it, the $6,651 in fees is associated with payments made by the estate to two law firms
Right, but like,
associated with a claim. And I'm saying that in air quotes because not because I dispute it, but because I know it is disputed, that may or may not have been asserted by a woman by the name of Jeannie Beck, who is an employee and friend of Ms. Duncan, but apparently was also a friend of Nani, and that after Nani's passing, there is clearly some dispute. Ms. Duncan is asserting that there is a claim against the estate or the possibility of one. I understand that language waffles a bit throughout some of the briefing, that at some point, perhaps at the beginning, she believed it was an affirmative claim. And then later, upon Ms. Beck's deposition, maybe thought that, okay, well, you know, maybe it was the threat of a claim. But I understand that that's the background here, and that because that payment was never made, the basis for the fiduciary duty charge shifted to the fact that attorney's fees were expended in alleged defense of a claim that was not presented. That's what I understand to really be the issue. Ms. Ross.
thank you, Your Honor. I'll tweak that a little bit. The testimony, the unrefuted testimony from Ann Duncan is that Nani said to Ann, you know, when I die, I'd really like to pay something to Jeannie Beck for her companionship or, you know, just for being with me. And in Ann's observation, Jeannie Beck did a whole lot for her mother. Now, as it turned out, at the end of the day, Jeannie Beck said, no, I never, she's my friend. I never meant to be paid for anything. Absolutely true. What happened is Ann told her sister that she wanted to make sure she was following the letter of the law and the will. And it was Ann's understanding or fear that, and this is before she knew that Jeannie Beck did not expect payment. All she knew was Mom said, pay her. And she wondered, well, maybe she can make a claim against the estate. I need to find out if, and this is before Jeannie Beck said anything about not expecting to be paid. So we're going.
Well,
on
Forgive me
what-
for interrupting. When were the fees incurred? So it's two different law firms, as I understand, but when were those fees incurred?
Very soon after Nani's death. So this is at the very beginning of the thoughts on distribution. So this is in 2018, right? So in 2018, in May 2018, Nani dies. By June 2018, Anne had sent her sister the estate account information. She had said, I'm trying to get some other property that you asked for. And she told her sister that I think we need to pay Jeannie back. At first, the plaintiff didn't object. Then the plaintiff did object. Now, when the plaintiff objected, Ms. Duncan still didn't know whether there could be a claim made by Jeannie Beck. And the word claim, frankly, Your Honor, Ms. Duncan is not a lawyer. She didn't use the word correctly.
Right, and I don't dispute that. I guess what I'm trying to get to, the place I'm trying to get to is this. At some point, at least by Ms. Calabrese's telling, an attorney would have looked at this and said, there's no written obligation. She's not named as a beneficiary under the will. I don't think this is a legally cognizable claim, whether it's a threat of a claim or a formal claim. And so I guess my question is, at what point did that happen relative? I mean, because
I got you.
in full disclosure, let's say I can accept Ms. Duncan's concerns, right? That maybe there is this payment that's due, and go hire an attorney and say, here's the estate, tell me, is this due? At some point, pretty quickly, the attorney's going to say there's no claim, there is a claim, whatever. And my question is, where does that fall in time with these fees having been paid?
When plaintiff said to her sister, I don't think Jeannie Beck should be paid out of the estate, that is when, and this is in 2018, that is when Anne Duncan went to estate counsel Mendon Fryman. Mendon Fryman ultimately said, you know, you probably have to pay her out, you'd have to pay her outside the will. She's not in the will. Do you want to do it as a gift? They're exploring different options. However, it was at that point, and this is all within a couple of months, that Anne said, you know what? I am not going to take any money out of the account. My sister doesn't want to. It sounds to me like this is going to be nothing. Now, Your Honor, in the correspondence, the Mendon Fryman correspondence with Alex LaVorse, and my own correspondence with Alex LaVorse, we use the word claim as well. Now, I'm third counsel in a long line, but we use the word claim as well. Now, that word, no one ever said a claim had been filed. No one did. Mr. LaVorse takes that to create this make-believe nefarious plot to take money out of the estate and give it to Ms. Beck. First, the argument is that Ms. Duncan wants to inappropriately use funds. And then the argument is that her counsel joins this conspiracy. Your Honor, this was a mistake. And ultimately, $12,000 some odd dollars came out of the estate, and Ms. Duncan offered to reimburse the estate. That's where we are. Now, when the complaint was filed, and I'll point out the testimony in a minute if Your Honor hasn't seen it yet. When the complaint was filed, Ms. Calabrese had already been told twice that no money came out of the estate for Ms. Beck, and twice had been offered the rings outside the estate, asked for an address. She never responded. The complaint, however, alleges falsely that upon information and belief, which is one of my favorite phrases, Ms. Duncan misused and misapplied funds from the estate On information and belief, Ms. Duncan used estate funds to pay her lawyers. On information and belief, Ms. Duncan paid her assistant $50,000 out of the estate. Now, she already knew $50,000 hadn't come out of the estate.
How
Plaintiff
did she know? Had she been told, or had she been provided with accounting documents that demonstrated that no such transaction existed?
both. Counsel told counsel, so
Mhm.
counsel was told that the money did not come out. And here's the thing about the account. There are two accounts. One is a very modest Wells Fargo checking account. It never had more than
14,000-ish.
Yeah, and that was Ann Duncan's money that she
Right.
put. The other account we're talking about is a Morgan Stanley investment account. Plaintiff and defendant are co-owners of the account. No money can come out of that account unless.
I understand that, but unless she had either immediate access to pick up the phone and call the bank and say, I am a co-owner of this account, tell me what transactions have occurred, or whether she was provided with a formal accounting by her sister, the executor, is different than being told that no such transaction has occurred. And so what I'm trying to get to is, as I understand, the reason that we are still talking about the allegation and the complaint of this $50,000 is associated with the attorney's fees and this argument that the complaint was frivolous, or at least this portion of the claim was frivolous.
Yes,
And
Your
so
Honor.
my point is, when an attorney and or a litigant says on information and belief, if they've not seen documents that would say definitively in a way that they would not question, right? I'm not saying it has to be definitive, but you get my point.
Yes, I did.
And so what I'm trying to get to is, did Ms. Duncan, I'm sorry, Ms. Calabrese, did she have access to the account, and or had she been provided with accounting documents that would demonstrate that no such transaction had occurred at the time the complaint was filed?
Was provided with the Morgan Stanley accounting documents regularly, usually monthly. She definitely had those documents. And she admits that she had no information on which to base a belief that at the time the complaint was filed, that $50,000 came out of the estate, or that Ann Duncan had misused funds. May I read you some testimony, Your Honor?
Yes.
Ms. Calabrese, what reason did you have to believe that your sister was not using appropriate funds? I don't know. I don't know. Then we go to, this is Mr. LeVar. Excuse me, Your Honor, I gotta find this. Okay, here we go. Ms. Calabrese, I'm trying very hard to understand your answer. I want to know if you admit that when you filed the complaint, you knew no money came out of the estate to pay Jeannie back. I can say that today, is our answer, okay? And do you remember when you found out, excuse me, do you remember when you filed the complaint about when that was? She didn't respond. I said, well, it was February 8th, 2021. At that time, you knew that no money had come out of the estate account, correct? No. You did not know that? No. I'm saying I don't know and had no idea what the finances were. Later on in the deposition, her counsel, Mr. Morse, brings out my letter of December 15th, 2020 that I mentioned earlier. And he said, do you remember, Ms. Calabrese, testifying that you did not know at the time I'm paraphrasing here, at the time the complaint was filed, that $50,000 never came out? Ms. Ross asked you early on if you had been informed that Jeannie Beck had not been paid out of funds of the estate. Answer, right. And you answered no, that you hadn't been informed. Yes, that's what I said, but I was wrong. Okay. There was cause to believe in good faith that this money had come out. And if you take a look at, he then introduces September 4, 2020 letter. And later on, although he didn't put this in the record, the December 15, 2020 letter that clearly state No money came out, and you can have the rings outside the estate. What's your address?
So Ms. Ross, all of that I understand. You still have not answered my question though. Did Ms. Calabrese have access to an account, or had she been provided with third-party documents that would more definitively? Because sadly, when lawyers tell each other things, they don't often or always believe those things all the time. And that is a sad state of affairs, but it is one that is true. So that's really, you haven't actually answered my question.
I'm very sorry.
That's okay.
All this communication is pre-lawsuit. And yes, pre-lawsuit, Ms. Calabrese had access to her account. It is a joint account. She could go to the bank, she can go online. It's a joint account, okay? So that is for sure. And pre-lawsuit, her counsel was informed. Whether counsel informed her, that I don't know. But there's no doubt that the account, the only account out of which that money could have come, is a joint account. Ms. Calabrese admits to having signed the signature card. She admits understanding that it is a joint account. She has access to those records, and she later got access as well in discovery. But before the lawsuit, this is her joint account. It's been her joint account since 2018. In fact, Ms. Calabrese, Ms. Duncan went to Morgan Stanley together with Nani, I believe, and some different accounts were split, but she personally was there at the bank to sign the signature card. There's no doubt that she had this information. Now, she may have chose to ignore it, but she certainly had access to it.
Okay. Okay. Ms. Ross, what I think I'd like to do now is hear from Mr. LaVorse regarding obviously any response he wants to make, but also the Helen May issue. And then because it's your motion, I'm always going to give you the last word. So I'll let you respond to that. But it would actually, I think, be helpful to me to have Mr. LaVorse lay out what that theory of recovery is before I hear your response, because I'm, as I mentioned at the very beginning, still a little hazy on that part. Okay. Sure. Thank you, Ms. Ross. Mr. LaVorse.
Thank you, Your Honor. Well, let's start with what we just said. Ms. Calabrese says in her affidavit, the first affidavit, and there are 3 of them, that she did not ever receive account statements from her sister prior to the lawsuit, with 2 exceptions. The first time was in shortly after Ms. Duncan was sworn in as executor. She sent her sister a snapshot of the Wells Fargo and a snapshot of the Morgan Stanley account. She did not get anything else after that June of 2018 until she hired me, and I requested documentation in around July of 2020. So it wasn't true that she was receiving statements all along. I can tell you that I've requested the actual account agreement from Morgan Stanley, which is not a bank, it's an investment brokerage outfit. And they have been unable to provide me with the account agreement. Now, apparently she was a joint account holder, but she did not have access to that account information. She had contacted the broker, who is Ms. Duncan's broker, several times requesting information. And as she recites in her affidavit, the broker didn't respond to her emails or her phone calls. She says unequivocally that she did not have any information outside of that until we filed suit. And interestingly, she says in a follow-up affidavit that we requested all the documentation that Ms. Duncan as executor is required to keep in discovery. And when it was produced, it was 103 pages short. There were entire, months that were missing. The only time we ever got full documentation is when we sent non-party requests to Wells Fargo and Morgan Stanley. That's the extent of the documentation. And if Ms. Duncan wants to say otherwise, and of course, we have a material fact dispute.
Well, hang on, let me
50
make sure. When you say a material fact dispute, I understand it. I mean, based on how you've presented it, let's say I agree with you that it sounds as if Ms. Calabrese was not getting, the documentation or accounting that I had been asking Ms. Ross, like, tell me where she had received some sort of third party. But at some point you received them, right, from in terms of a third party request. And so there's no longer a dispute about the transactions that went in and out of that account. We know what they were. And other than the attorney's fees that are the subject of the breach of fiduciary duty claim, it's undisputed that there was no transaction in favor of Ms. Beck, this $50,000 that was originally the subject of the complaint, correct?
That's correct. That's absolutely correct, Your Honor. And again, we're talking about years after we filed the lawsuit when we were able to satisfy that. And again, the on information and belief that she was paying $50,000 was just that based on the intelligence that we had when we filed the suit. That's not the claim. That's just one fact supporting a breach of fiduciary claim. The breach of fiduciary claim, you laid your finger on it very early on, was this hoax that was perpetrated by Ms. Duncan. Now, I think Ms. Duncan's counsel is somewhat confused about the timing of all of this. Very early on, Ms. Duncan had asked her then attorney, Menden Fryman, to draft an assignment of part of the inheritance of the two sisters to Jeannie Beck. And you ask yourself, why would you proceed in that fashion if she didn't already know that there was no valid enforceable gift that her mother made to her? And that's in that, you can see all of that in the invoice of Menden Fryman. It's attached to the first affidavit of Ms. Calabrese. It's dated July 25 of 2018, and that's all it did. And it basically runs through June. Apparently, Ms. Duncan sent the assignment to my client. My client said, heck no. This is and we know heck no by July 6th, because that also is in an email attached to Ms. Calabrese's first affidavit. In response, and I presume the court has read Exhibit G to that affidavit, which is the email of August 30 of 2018. And if I may, I would like to read a little bit of that to the court.
You can. Is this the one where Ms. Duncan outlines the amount of hours and how she gets to the value of the potential claim?
Yes, it is, Your Honor. And when you say outlines, there wasn't any confusion in Ms. Duncan's part at that point. She says visiting Angel's conservative hourly rate of $30, and based on the hours that Jeannie has calculated, those hours equate close to $40,000. Well, that's just flat out a falsehood. Jeannie Beck, I asked her in her deposition, I outlined it in detail in our responsive brief, was very clear that she never did any such calculation. She never did any services for her friend expecting to be paid. She never discussed being paid with Ms. Duncan or with Ms. Calabrese. Ms. Calabrese never said, I'm going to leave you any money. Ms. Sigafoose. Yes, ma'am. And at that point, it's pretty clear that she just made that up. All right. She had known by August 30, because she had in the opinions of two counsel that there was no enforceable gift. And she also knew that she's spending money to get the opinion of counsel that there was an oral contract. Well, again, there's no oral contract. There's no party to the contract. Oral
Two
contract to
questions,
make a
Mr.
gift.
Two questions, Mr. LaVorse.
Sure. Yes,
One
sure.
is, would you agree that however it might have been structured, if there was any concern on the part of Ms. Duncan that there might be a claim that was owed by the estate, that it would be reasonable for the executor to pay an attorney to confirm or determine if such a claim was viable?
Yes, it would. But again, the only way they would have ever proceeded to the oral contract was if there were a discussion between the decedent and Ms. Beck. They're the only parties who would have been parties to that oral contract to make a gift. And Ms. Beck again has said, we never discussed the issue. Everything I did was out of love and affection for my good
Right,
friend.
but Ms. Beck saying she never discussed it doesn't negate the idea that Nani told Ms. Duncan, which is what I understand her position to be, that during her life, Nani said, I want you to do this for Ms. Beck. And again, I'm not presupposing that any of those facts actually exist. What I'm trying to get to is this. Assuming for a moment that everyone was coming from a place of good faith for the moment, I understand that y'all don't agree on that, but would it not be proper for Ms. Duncan to say, hey, I have this estate. My mom told me I was supposed to give this money to somebody. What do I do? And the attorney, and have the attorney expend some time and effort saying, there's no theory of recovery that would allow this person for you to either enforce against the estate to the benefit of Ms. Beck, the oral promise that you say Nani made, or she's not an heir under the will. Why is that not a legitimate expense for the estate to have accrued?
Well, again, Your Honor, there was no promise from Nani to Ms. Beck. So there's no fact on which a contract could have ever come into existence. And the same thing with respect to quantum merit claim. You know, as we pointed out in our brief, there can't be a quantum merit claim based on services rendered for love and affection.
Okay, my second question, Mr. LaVorse, is this. So I'm not a probate lawyer, never practiced probate law, don't know anything about probate. But one question I have is that the estate, I think clearly was to be divided equally between your two clients, Ms. Duncan and Ms. Calabrese. And so my question is, if there is an argument that the estate fees should not have been spent, isn't your client, even if I agreed with you, wouldn't your client only be entitled to half of that amount because she was only entitled to half of the estate? Or am I not doing my probate calculations correctly?
Your Honor, I think the math is correct. I would say that there is a considerable larger amount in fees in dispute or potentially in dispute than what Ms. Ross originally alluded to. There were not only these two original invoices in 2018 from Ellis Funk and from Menden Fryman, but during discovery, we had requested all of the pertinent attorney's fees statements. We got them on the morning of Ms. Duncan's deposition. They are attached to the affidavit of John Blaustein, our affidavit on these fiduciary accounting duties. And if you look at them closely, they're interesting because they're entirely barren of any description whatsoever of what the services were for, how much was employed for any particular task, who the attorneys were. Two or three of those invoices that were produced, in fact, don't even recite that they were for the benefit or for the estate. We did also produce the corresponding checks used to pay those. And again, Mr. Blaustein is opined that every one of those invoices and the condition in which they were rendered are violations of the fiduciary duty the executor owed and should not have been paid without the requisite information. And again, you know, when you look at, it's hard not to be cynical when you look at the state in which those later in time invoices were produced, when Ms. Duncan knew that we were questioning what she was spending estate funds on. I believe the total of those was a little under $20,000.
And
You're
are
right
those,
that as half our beneficiary equal to half, then she'd only be entitled to whatever was provable. That's correct.
okay,
And Ms. Ross at one point said that Ms. Duncan had offered to return half of that. As my client said, I believe in her second supplemental affidavit, that never happened before we filed suit. And again, if
well,
she makes an
and
offer.
going back for a moment, Mr. Livermore, the blank invoices that carry the additional dollar amounts of attorney's fees that you find problematic, that don't have fulsome descriptions of activity, are those post litigation, pre-known litigation, or like in terms of their timing?
Well, they ostensibly were before we filed suit, though they were produced 2 years after the fact in June of 2022. And interestingly, if you look at the way the formats of those, that first invoice that's attached to the first affidavit of my client, the one dated, I believe, July 25th, it has some detail. It's not itemized per activity, but it has some detail. But then you look at the ones that were produced 2 years into the litigation when we'd constantly sought them, and all of that's gone. Again, I don't mean to sound cynical, but we don't know when they were produced. I think at the very least they were produced after we had raised the issue with Mendon Fryman, Samantha Page, questioning the use of estate funds to pay for those activities. Then all of a sudden they went dark.
Okay. Same question about the rings. So one of the issues that I believe I understand Ms. Calabrese's position to be that those rings belong to her. They'd been gifted to her by, I think, Helen May, although that's different than the amended complaint matters. And that the fact that Ms. Sigafus was in possession of them at the time of her death it was not indicative of her ownership. It was because she had loaned them to her. And then Ms. Duncan's position is those rings belonged to Ms. Sigafus and therefore are part of the estate. Is that, in a nutshell, the correct nature of the dispute?
That's a pretty good characterization of it. Yes, ma'am. Yeah, again, the rings came as a gift from their paternal grandmother. Same time, and Miss Duncan admitted this in her deposition, same time she got a Chevrolet Impala and another ring as part of that transaction. Helen May was moving into a senior facility.
So let me stop you. Sorry, Mr. Lavorse. I apologize. I keep jumping in and not letting you guys have any narrative thread to your argument. So I apologize.
That's perfectly all right.
After the deposition, and I'll ask Ms. Ross the same question when I'm speaking with her again. Is there now, am I correct? Is there now no dispute that the rings are not estate property, or is there still a dispute that, because the nature of the claim is is a conversion claim, as in these are mine and you refuse to give them to me. And the briefing that I saw seems to imply a concession by Ms. Duncan that these are not estate property, but I'm not withholding them from you. That's why it's not conversion. Is that correct? Is there no longer a dispute that these rings belong to Ms. Calabrese?
Well, Your Honor, again, we're talking about, we assert that the first act of conversion occurred as early as 8/30 of 18, when she said, these are not your rings. I'm going to dismantle them and scatter them to people who weren't even beneficiaries under the will. And as we pointed out in our brief, it doesn't matter if she's mistaken about who owns the rings. That's not an issue in conversion. It's whether you do something that's contrary to the
No,
rights to
and
possession.
to be clear, that's not the reason I'm asking, right? The reason I'm asking is I'm trying to figure out when on summary judgment, if there are disputed facts, I'm just trying to figure out, is the ownership of the ring of those two rings in dispute? Whether she wrongly withheld them presupposes that Ms. Calabrese is either entitled to both rings in their entirety because they were hers, or is entitled to half of them because they were estate property. And that's what I'm trying to figure out. Now, I concede, as the court, there's probably a dispute here about whether or not the actions by Ms. Duncan constituted an intentional deprivation or an effort to convert that property. But I'm trying to figure out if there's an agreement on whether the property belonged in its entirety or half of it, and its value belonged to Ms. Calabrese. That's what I'm asking.
Okay, Your Honor, again, obviously, it's our position that she owned the ring since the early for mid-1970s. As Ms. Ross has asserted at various times, there have been offers to deliver them to my client. As Your Honor noted, we contend that every one of them prior to suit were offered on condition, an impermissible condition, including there was a letter from Samantha Page in October of 2020, in which she said, you can have the rings, but we're going to deduct them from the value of the estate. Now, yes, there have been settlement offers and counter offers since then, but those certainly don't negate the question of whether the rings were converted. And that's what we're suing for.
Okay. Now, Mr. LaVorse, walk me through the Helen May issue. I think I understand that there is that some of the property of Helen May ended up in the possession of Ms. Duncan. And it is unclear to me in the pleadings whether that's because they belonged to Nani, and Nani throughout the course of her life gave them to Ms. Duncan, or that Ms. Duncan took possession of them, or what is the legal cause of action that Ms. Calabrese is asserting to assert that she's entitled to some or all of that property?
Okay, Your Honor, the property in question came from Helen May. Again, when she went into the senior living facility, she downsized, as you can imagine. She was living in a rather small apartment. She gave a lot of antiques, furniture, furnishings, silverware, dinnerware to the parties. Then everyone was living in Ohio. My client and her mother, the decedent, moved to Atlanta and brought a lot of that property with them. Ms. Duncan later moved to Atlanta, I believe, after she graduated from college. Now, at the time of the delivery of all of that property, the antiques, and there's a list of all of that attached to, I believe, the middle affidavit of my client. It was the understanding of all the parties that that would be kept in the family house until the time that the decedent passed away, and then they'd be divvied up. My client married, moved out west, and all that property remained here.
So is the
Sigafus-
issue that Ms. May's furniture was estate property and it hasn't been distributed as part of the estate or accounted for as part of the estate?
No, Your Honor, it absolutely is not estate property. Again, if you keep in mind that around the time that all this was happening, Helen May's son was divorcing from the decedent. That property, again, was just delivered to the common household, as it were, but it was never designed to be the decedent's property. So it's non-estate property, and I think that there are several points in the depositions where they recognize that fact. But I will say that it took it took a bit of study, as it were, to sort that out.
Okay.
The property was always Helen May's, delivered to the girls, Ann, Duncan, and my client. There was a common agreement it'd all be divvied up. It all ended up in Ms. Duncan's home. Apparently, she has a rather large home out at Horseshoe Bend, if I'm not mistaken. Ms. Sigafus was living with her for many, many years. Now, when Ms. Sigafus could no longer live with her and moved into, again, a senior residence type arrangement at Atria, she brought some of that furniture and furnishings with her, and it went all back after Ms. Sigafus passed away. So the long answer to your question is no, it was never estate property. The cause of action, again, is almost identical to the same fact pattern in that case that I cited, Braswell versus Benton. Your Honor, it's at 351 Georgia Appeals 372, 2019. And in that particular case, that's exactly what the Superior Court was asked to do. We're alleging that we haven't been able to get our share of the non-estate property in the possession of Ms. Duncan for the same reasons we haven't been able to get our share of the estate property. And in
So let me go.
Braswell,
Forgive me for interrupting you, Mr. LaVorse, but let me go back a moment to my earlier statement that I have never done probate law. Okay, so here's where I'm confused. I understand why one might characterize the rings that are at issue as non-estate property, right? Because there seems to be some understanding that property might have been given directly to Miss Calabrese at some point in her life, right? As in other words, it did not go into the possession of Ms. Sigafus to be distributed as part of her estate. What I am less clear on is if this alleged distribution of property from Ms. May happened literally decades ago, and Ms. Sigafus was functionally in possession of it for all of those years, how is it not estate property? And if it's not estate property, then how does Ms. Calabrese have any claim to it? That's what I'm a little confused about.
I can
Well,
answer
Your Honor.
that question, Your Honor.
Hang on, Ms. Ross, just make notes and I'm going to ask.
Oh, I'm sorry. I'm so sorry, Your Honor.
No, I'm talking to Mr. LaVorse.
yes, Your Honor, again, it's the simple answer is it wasn't a state property of the decedent because it was never given to her by the owner. It was possession was physically transferred. Again, all three of these principals were living in the same house in Ohio when this occurred. It was all transferred to that physical house with the understanding it was going to Ms. Ms. Calabrese and Ms. Duncan at the time Ms. Sigafus passed away. So it could never have become part of Ms. Sigafus' estate because she never owned it.
I understand that argument. I think where I'm confused is if this had happened 2 years ago, I would probably agree with you. But when it happened 20 years ago and she continued to openly and adversely possess the property, exercising dominion and control over it, I understand your position is that she was simply safekeeping the property. I'm struggling with that one a little bit, but I get your point that Ms. May gave it directly to the children and that Ms. Sigafus was merely in possession of it, and everybody understood, albeit absent any sort of writing or inventory, that at some point that property would become the property of Ms. Duncan and Ms. Calabrese.
Well, Your Honor, the only thing I would say about that is no, the mother never exercised dominion and control, asserting that she had an ownership interest in it. She never did that. It's nothing more than borrowing property, so to speak.
Well, didn't she move it from Ohio?
Yeah, she did. And
Georgia?
when Yes, and when that move occurred, she moved in with Ms. Calabrese, as I understand it. They brought it all down to Atlanta at a time when I believe Ms. Duncan was still in college.
Okay,
But again, the understanding from the get-go was it was never going to be Ms. Sigafu's property.
okay, okay. I think I understand, at least better than I did before. So thank you, Mr. LaVorse. Anything you want to add before I allow Ms. Ross to reply?
Are we talking about to everything or?
Yes, sir.
To this particular? If I can look at my notes for just
Sure.
a minute. Well, again, Your Honor, getting back to the breach of fiduciary duty, and it sounds like you read the letters and the correspondence that was attached to especially the affidavit of Ms. Calabrese that we filed in September when we first responded to the motion that hadn't been filed yet. And that September 4 letter from Samantha Page at Menden Friedman, she said unequivocally that Jeannie Beck had presented a claim and her law firm was hired to represent the estate in resolving that claim. That ought to be troubling to the court. I will say that Ms. Duncan's current attorney made the exact same representation in December of 2020 in that letter to me. I believe it was December 15. Again, it's attached to an affidavit that Ms. Beck had presented a claim. And at the time, they knew there was no claim that was presented. Ms. Duncan again admitted in her deposition that there wasn't any claim that was presented. And that's the crux of the hoax claim. Ms. Duncan was copied on both of those letters. They never did anything to correct any of that. We filed suit in February of 2021 during the height of COVID, as I recollect. So when she says that she thought there might be some claim that was presented, she said flat out that she had a right to present a claim. She told apparently Ms. Duncan how many hours that tallied, and then she either told her attorneys that the claims had been presented or had sat by in her hands when they made those representations to me. And again, we're saying, these attorneys are being paid for all of this correspondence back and forth, and we think it's improper. And when we raise that claim, they're hiding what they're doing in the statements that were produced when Ms. Duncan filed her or served those statements to us on the morning of her deposition, right before her deposition. And that's, I think, what we need to keep in mind with respect to the breach of fiduciary claim. And again, I don't want to beat a dead horse, but Mr. Blaustein does a very good point in explaining what the amount of the damages are, money damages are, and why they are breaches. And as we pointed out, not only are those the only claims for relief, but we're asking for an accounting, a strict accounting, because we don't know, based on what we've been furnished by them, what transpired between Ms. Duncan and Menden Fryman. And we're asking that the court order her removal as executor for that. And I would like to say one other thing before you turn the floor back. Ms. Duncan has asserted that this court doesn't have the authority to order an accounting or order the removal of the executor, and that's simply not a correct proposition of law. If you look at the Braswell case that I just cited earlier, that specifically held, it was a Superior Court case where the action was commenced, that the party who asked for the accounting was entitled to it. And it also referenced in that case, a second case, Powell versus Thorson, which is at 248 Georgia 697, 1982 case. Again, there was an action that was brought in the Superior Court of Colquitt County seeking an accounting and removal of a fiduciary for breach of a fiduciary duty. And again, the real question is yes, those things traditionally are things that might be heard by the probate court, but when the probate court can't grant relief, as in a case where there's conversion and not estate property, it's not only proper, but it's the right thing to do for the Superior Court to grant complete relief in one action. And that's the clear holding of both of those cases.
Okay, thank you.
Thank you, Your Honor.
Ms. Ross?
Hello, Your Honor. Your Honor, I'm going to keep this, I'm going to get us back from Netherlands and talk about what's relevant. First of all, the Braswell case dealt with a directive in a will regarding estate property. It is completely distinguishable, and that's really all we need to say about it. What is at issue here? According to the pleadings that are most recently filed by the plaintiff, the breach of fiduciary duty claim is for half of $12,000 some odd dollars in attorney fees paid to Mendon Fryman and to Ellis Funk. Now, that's their number. Okay, I didn't make it up. Now, Your Honor, I'm going to keep addressing these claims before I get into the 915-14 claim, but it does dovetail. As far as Helen May's property is concerned, Helen May Sigafus is the paternal grandmother of the parties. What plaintiff is alleging suddenly, after a year and a half of litigation in an estate dispute, she's alleging, she didn't allege any agreement. We look at the amendment to complaint. She said, well, there was all this property, it was the 1970s, and there was this understanding that someday we would divide it. Not what property went to whom, nothing. And the amendment to the complaint says, Your Honor, everything got intertangled at some point, and we don't know how, but please divide up these 13 pieces. It's about 13 pieces of personal property, 6 of which have been offered to the plaintiff. Okay? Now, I'm sorry, Your Honor. I just don't think the good people of Fulton County need to come in to talk about whether the other 7 pieces of property, whether they exist or not. It's just offensive. Second.
Well, I think the issue that I'm struggling with, and you heard me say this to Mr. LaGorce, is absent a writing, I don't understand, and given the passage of time, I don't understand how that property isn't estate property.
I can tell.
And there's no.
I can help with that.
Okay, go ahead.
That property, the property, there is not a dispute that Helen May's property wound up in Atlanta with Nani, and Nani lived for 25 years with the defendant. And that property, most of it, is in the Duncan home. Some of it's in the basement, some of it was around the house. And here's what happened. When Nani moved to Atria, Nani, and this is undisputed testimony, Nani said to Anne, Anne, I'm going to take to Atria the property that is my home. I'm taking it. Everything else is yours. Do whatever you want with it. The plaintiff has offered nothing to refute that fact. So the property that belonged to.
Okay, but and this is why I'm confused, because Both of y'all are saying it's not estate property, but you're saying it's not
No,
estate
I'm not.
property for two different reasons.
I'm not saying that,
Right.
Your Honor. I want to be clear. The property that originally belonged to Helen May, that Nani claimed as her own, she took to Atria as her property. And that's estate property. So there's a lot more, I understand, of Sigafu's property that
Right, but your
There's no
position
claim
is
here.
that what she left at Duncan's house isn't estate property because she gave it to her daughter, Miss Duncan.
absolutely. And frankly, Miss Duncan would like nothing more than to get it out of her basement. But that is our position. Yes. And that makes
Okay.
legal sense, right? Since under the will, the executor has the discretion to determine what property is part of the estate. And Nani directed the executor that I'm going to take with me to my new home at Atria the personal property that is mine. The rest belongs to you. Now, whether or not you have the right to give it to, and I don't know, but again, this comes down to $6,000 in attorney fees, Your Honor. And
Okay.
all of this discussion is, and I will tell you, Mr. LaVorse is doing his best to bring in a bunch of facts, but they don't matter to the
Well,
claim.
Let me
And-
ask you a couple of questions, Ms. Ross.
Mhm.
So there were a couple of questions I asked Mr. LaVorse,
Mhm.
and I mentioned that I was going to come back to you, and this is going back to the original claims. Is there any dispute? Mr. LaVorse seemed to indicate that Ms. Duncan conceded that the rings that are at issue had been gifted to Ms. Calabrese by Ms. May way back in the 70s, and that they belong to her and are non-estate property. Is that, are we in agreement on that issue?
No, we are not.
Okay.
Ms. Calabrese-
Well, hang on.
There is no longer a dispute because Ann Duncan gave them to her sister and said, you can have them outside of the estate. I don't want to argue about it anymore.
Right,
They're
but
yours.
saying I don't want to argue about it anymore here is not the same as, do the parties agree that these rings belong? I'm not asking if you wrongly or not wrongly withheld them. Do the parties agree that the rings belong in toto as non-estate property to Ms. Calabrese?
Yes, we do. We agree.
Okay.
We agree to that.
Okay.
And I want to point out that before the lawsuit was filed, Ms. Duncan offered the rings outside the estate at least twice, and we have the writings that are in the record, and even asked for an address. And Ms. Calabrese never responded.
Right. And I understand that, but it is helpful to me to understand that apparently Ms. Duncan also agrees that those are non-estate property that belong to Ms. Calabrese. The only issue is whether the possession of them, because let's not forget, it hasn't been mentioned in this hearing, but the reason Ms. Duncan has them in her possession is because Ms. Calabrese went and got them and gave them to Ms. Duncan.
Thank you, Your Honor.
Very, very odd and
Yes.
ironic in this context.
Thank you, Your Honor, for having read these,
Second
all of this
question.
so carefully. Mhm.
Second question, Ms. Ross. It's sort of the reverse of what I asked Mr. LaVorse a moment ago. Do you agree with me that whether or not Nani either instructed Ms. Duncan to make a payment to Ms. Beck, or whether Ms. Beck had made a claim of some sort or could make a claim of some sort, is a disputed issue?
No, it is not. It is not an issue of material fact in this case, because the will states, and it is undisputed, that the will states that the executor has the right to hire attorneys for questions about the estate. The unrefuted testimony of Ann Duncan is that she hired these attorneys to see whether or not estate funds could or should be used. And even if Ms. Duncan made a mistake, let's say she was wrong, she misunderstood what Ms. Beck had done for her mother. That's not a breach of fiduciary duty. That's a mistake, Your Honor. There is nothing, the only thing in the record that suggests any ill intent on the part of Ms. Duncan are Mr. Lavorse's words in the adverb-laden brief. That's it. There is nothing. Also, Ms. Calabrese does not refute that what Nani said to Ms. Duncan about Ms. Beck. But again, let's say Ms. Duncan were wrong. You can make a mistake. And ultimately, she said, I am not going to take money out of the estate. Now, as far as the damages that are alleged, and again, in the amendment to the complaint, it's alleged as half of $12,000 some odd dollars. During this lawsuit, there have been many back and forth demands about property and this and that. And one of the things that Ms. Duncan offered to do was just make that go away. Let's just put that back in the account. And I have case law, Your Honor, and I'll cite it right now, that under 915-14, refusal to accept objectively appropriate offers that will cure claims is evidence of vexatious litigation. And remember, these are, I will cite them right now. And Your Honor, I'm sorry, I've got so much stuff here. Okay. That's Anglin. Okay, one is Franklin Credit Management versus Friedenberg, 275, Georgia App 236. This is a creditor-debtor matter, and the Court of Appeals held that the debtor was entitled to attorney fees for having to defend a complaint where there were many offers made. Now, the creditor also wanted to get 915-14 fees, and the court said the creditor waived this argument because the specifics of settlement offers between the parties can be recognized, but they're waived here because the creditor said the evidence was inadmissible. So we have the same thing here. We have pre-lawsuit evidence unrefuted, showing that allegations in the complaint are flat out false, intentionally false. That's the beginning of 915-14. Then we have Ms. Duncan's efforts, and she testified clearly, I don't think any of this stuff belongs to my sister, but I don't care. This is a family dispute. I want it gone. And she made every effort to make this case go away. Second case is Apt, ABT, the Apt, 289 Georgia, 66. The trial court did not abuse its discretion in awarding the husband attorney fees based on its finding that the wife's actions unnecessarily expanded the litigation.
Well, but so let's all take a step back for a minute and remember where we are procedurally, right?
Yes. Mm-hmm.
I am not the finder of fact at this moment. And while I might have opinions about the unfortunate waste of resources between two sisters who really shouldn't be fighting over all this stuff and what a horrible shame it is in the grand scheme of things, none of those things matter because that's not the issue that's in front of me right now. Right now, the issue in front of me is whether there are facts that create disputed issues that are genuinely material to the issues in the case that require resolution of credibility, or that require resolution of a dispute of a material fact. In other words, that require a jury.
Thank you, Your Honor. I'm sorry.
All of the conversation about the 915-14 issue, I think it's in large part we're putting the cart before the horse here, because if I grant summary judgment, then maybe I will entertain a 9/15/14 motion. But if I deny summary judgment, then that is likely an issue that will either be addressed in some measure by a jury or by me at some point in the future. But either way, we're not getting to 9/15/14 today.
Thank you. I did
So-
include it in the motion for summary judgment, but not as to amount, but I understand you and I will not mention it again.
Okay.
I cited a case that addresses the affidavits that 3 or 4 of them that the plaintiff submitted in response to the summary judgment pleadings filed by Ms. Duncan. And that is Anglin v. Harris, 244, Georgia App 140. And in a nutshell, what this case says is that the non-movement who offers self-serving affidavits and other testimony, if available, that contradicts undisputed evidence already in the record does not defeat summary judgment.
Well, I mean, I'm very familiar with the concept that self-serving, one-sided testimony, particularly if it's contradictory, isn't to be considered in a summary judgment motion. But if I need you to be specific about, I need you to show me where her affidavit testimony specifically disputes something that she previously said in a deposition, or a fact that she's now attempting to walk back.
Your Honor,
By way of example.
I will be happy to do that. That's a lot of affidavit testimony. I'm not prepared to do it now, but I can do it.
Okay.
And Your Honor, I want us to focus on what this case is about and then talk about the amendment to the complaint. This is an estate dispute. All during litigation, discovery, all this non-estate property was being brought up by the plaintiff. She went from asking for 6 items to 60 and then back to 30 and all that. But it was all about estate property.
Well,
It wasn't.
yes and no. I mean, the rings, we seem to have finally gotten to a place where we acknowledge that they're non-estate. And Mr. Lavorse's position is that the reason this matter had to be handled in Superior Court is because there were non-estate claims. I understand that the way this all came up was probably the sisters arguing over the estate, again, using air quotes on purpose. But it seems quite clear to me that fairly early on, there was an understanding amongst the parties that there was a dispute about whether property was in the estate or not in the estate. And if it was in the estate, how it would be distributed. And if it wasn't in the estate, how it would be distributed, i.e. the rings. Anyway, go ahead.
I don't believe that was a material issue of dispute, because the will gives Ms. Duncan the right to state what is in the estate. And the unrefuted testimony is that Nani asked her to do that. Not only is it in the will, but Nani asked her to do that. There's absolutely no testimony to the contrary. And it wasn't until the reply in support of summary judgment was filed, which makes it clear that plaintiff protracted the litigation vexatiously by talking about non-estate property. Wasn't until then that all of a sudden this non-estate property of your paternal grandmother comes into play. Your Honor, I want to look at the amendment to the complaint. The amendment to the complaint does not state any legal claim to the property that is sought. And some of the property on that list is estate property. Some of it is not estate property. What is estate property has already been offered to plaintiff. What are we going to ask a jury to do here? It is beyond me that we can bring in a jury of people from Fulton County, and I don't know what they get paid every day, but I'd be embarrassed it is just, and Your Honor, I have to say one other thing. If I've already said this, I'm just getting old, so tell me to be quiet. I've practiced law since 1990. This is the first time I have brought a 9-15-14 claim against opposing counsel. I have never done it before. And I wasn't going to do it here, which is why I didn't give my fees records. But I made up my mind that I would when I looked at the outright falsehoods in the responses to summary judgment and the outright falsehoods I've heard today, objectively so. Your Honor, I don't take any pleasure in this. It is the first one I have ever filed. I don't like it, but it is the right thing to do for my client.
Okay. Well, we're not going to deal with 9-15-14 today.
I know.
Because as I said, if I grant summary judgment, then I will entertain a motion if you file one, at which time Mr. LaVorse will be able to vindicate his legal position. If I deny summary judgment, then that's a horse for a different day.
Of course. Okay.
I think I just mixed some metaphors and cliches and all sorts of other things, but you get my point. So circling back to the original, I do want to ask one last question. Well, I take that back. I don't really want to ask one last question. Here is what my thought process is, just so y'all have an understanding of where I am and what I'm doing. So as I said a moment ago, let's all back up and remember where we are procedurally. As I said a moment ago, if there was the potential for a claim, whether because Nani said do it or because Ms. Beck was making a claim or because there was the possibility she could make a claim, then I agree with Ms. Duncan that it's probably appropriate for an executor to inquire. However, I think that Mr. LaVorse has done a fairly decent job of muddying the waters in terms of whether or not there are disputed facts that would imply that there was a good faith basis to pursue that inquiry. As in, and even the way I'm hearing it phrased today even is whether it could be done or whether it should be done. Those are different issues than I have an understanding that I potentially have this legal obligation on behalf of the estate. Do I have to satisfy it? And so I think that there are disputed issues as to the circumstances of how Ms. Duncan came to believe or understand or inquire with lawyers as to whether this payment was legally obligated to be made or could be made from the estate. And because of those factual circumstances being in dispute, whether any such statements were made by Nani, whether any such claim was ever asserted by Ms. Beck, I think that whether those attorney's fees were expended on behalf of the estate at a minimum is a factual dispute that prohibits me from resolving the fiduciary duty claim, except to say this, as I said, if a finder of fact determines the fact that there was this possibility of a claim, then I personally am of the opinion legally that the necessary relief follows from there and the necessary claim fails, right? That there is no breach of fiduciary duty claim as the expenditure of attorney's fees if a finder of fact determines that there was a reason to inquire about that issue. But whether or not there was a good faith basis to inquire about that issue, I think is still up in the air and is not appropriate for me to resolve on summary judgment. Now, whether I think we've established, and it's important to me when I ask that question, that when we go forward to trial, we're not going to go back and trot over old territory. I think we've established for the record in this case as it goes forward that Ms. Duncan and Ms. Calabrese agree that the rings that are at issue in the conversion claim belong to Ms. Calabrese by virtue of having been gifted to her by Helen May a bajillion years ago. Whether that fact is in dispute or not, I believe that I am also foreclosed from granting summary judgment in favor of Ms. Duncan on that issue because while I agree with you that there seem to be two offers of take the rings, there seem to be other offers and other circumstances that carry with them strings. And whether or not that is an exercise of dominion or a wrongful retention of property when it's been demanded, I think is a factual issue for a jury, for a fact finder to resolve. Now, I say all that because to me, whether ruling on summary judgment, denying the summary judgment on the conversion claim, as to the rings, whether the parties agree on who owns them or not is not dispositive for me for purposes of my ruling today. However, it is important to me that if y'all have said we agree, that we're not going to go back to trial and start arguing something entirely different. But I guess that's y'all's issue. The remaining claims are for punitive damages and for attorney's fees. The attorney's fees, I've said, I think are premature. The issue of punitive damages, I will just tell you that generally speaking, I'm not a fan of punitive damages, particularly in cases where what we have seems to be a dispute among the parties. However, I believe that breach of fiduciary duty can be characterized as an intentional tort. And if it were proved in that manner, there could potentially be a basis to seek punitive damages. But it is something that after I hear the evidence at trial, I would be very likely to grant a DV on unless the evidence is compelling.
Your Honor.
As to the new complaint, the amended complaint that adds these new issues, it annoys me, Mr. LaVorse, that this was filed so late in the day at the 11th hour, but the case law is what the case law is. The statutory law is what the statutory law is. It is that a party can amend their complaint at any time prior to the filing and entry of a pretrial order. One has not been entered in this case. And as I understand it, although Ms. Duncan says there's no cause of action, as I understand the purpose of asserting if, I guess, whether they're estate or non-estate property, they can be, those facts, the alleged property can be shoehorned into either of the claims. Because if they're estate property, then they allegedly have not been accounted for and have been withheld wrongly. And if they're non-estate property, then they've been converted. So this is all a big mess that is going to have to be resolved by a jury. And so my rulings in a nutshell are, Mr. LaVorse, please provide me with a proposed draft order that denies summary judgment and that denies the motion to strike the amended complaint.
Your Honor, may I say, I'm sorry.
Sorry.
Well,
May I
hang
say
on. Yes, sir.
one thing about the motion or the amendment and your annoyance? The dispute dates back in paper to at least the Samantha Page letter to me of September 4 of 2020, in which she recites on one page that the Lincoln Rocker, which is part of Helen May's property, is requested by Ms. Duncan. So that far back, she's staking a claim to what she wants out of that.
Mr. LaVorse, two things. One, as I tell my kids, stop selling. I'm already buying. Okay. That's number one. Number two, I understand that you want me to think that you have to not think that you or your client have been, late in asserting these claims, but it's not going to change my annoyance. You're illegally entitled to add facts to your complaint, and that's why I am denying the motion to strike them. But the fact that it's been at issue for as far back as you say begs the question to me even more: why weren't those facts asserted in a lawsuit earlier on? It doesn't matter legally.
Your Honor,
yes, sir.
Your Honor, what I was hoping to finish with is that honestly, again, there were a couple other things in that letter, September 4. It honestly didn't really crystallize in my mind until after the depositions of the parties were taken. And I was preparing the responses to the motion for summary judgment. That was the point at which it crystallized to me that we had this other issue that needed to be resolved, and it wasn't a state property. So what else are you going to do?
And
And it
again,
was shortly after that.
I didn't mean to imply when I stated my annoyance, which still exists. I didn't mean to imply that I thought that it was put forth in bad faith or for undue delay or any other improper purpose. It just pushed the case off of the schedule that I wanted it to be on.
I understand.
But in any event, if you can draft 2 proposed orders, one denying the motion to strike and one denying the motion for summary judgment, if you will submit it to Mr. Freehoff in Word format, and make sure to copy Ms. Ross. Ms. Ross, I will tell you what I tell all attorneys. I understand that you disagree with the outcome of my ruling, right? But if the order that is proposed to me by Mr. LaVorse does not accurately reflect the outcome of the hearing and what I have said today, please bring it to my attention. However, please do not look at that as an invitation to re-argue the issues. I have made my ruling.
I understand.
Okay.
May I ask you a question?
Yes.
On the conversion claim, there's no remedy to be had. The only thing we don't have is an address. I mean, so even if Ms. Duncan had wrongfully converted, or if there's a fact issue, she's already offered the remedy. She's already offered to give back. I'm not understanding why a jury has to decide that when she's already agreed.
Well, because the causes of action, the elements of a cause of action for conversion are wrongful retention. And the allegation is that at various times, Ms. Duncan has continued to retain it in her possession wrongly. The fact that she's offered to give it back is going to be a fact issue in the case. Now, what I would like to do is note that this case was previously on a trial calendar and was moved off of that trial calendar because of this summary judgment hearing. And so I do want to make sure that you are all aware. I don't know exactly which calendar you will be on, but I know like what day, but I would expect that you could anticipate appearing on a calendar in the last 2 weeks of February at the soonest, or the last 2 weeks of March at the latest. And that would just depend on conflicts, leaves of absence, and other cases that I have that might be older than this one.
Your Honor, may I remind the court that the reason for the scheduling not only was because of the reset over motion to strike, motion for summary judgment, but my client had an emergency.
Oh, that's right. She had knee surgery or something.
Knee replacement.
Ooh, okay.
And the rehab is not going particularly well. Mr. Freehoff had indicated to me that based on the physician's report, the earliest it would be the end of March.
You are correct. And I do remember that, but you just had to remind me. Now that you mention it, I do remember seeing that issue and that we would protect the case until March.
Thank you, Your Honor.
So the other question I have is, have the parties attempted to mediate this case? I mean, other than emails back and forth among and between the sisters, have the lawyers actually sat down in a room with a mediator and tried to figure this out? Because no offense, because I know that there's a lot of emotional, everything that goes with this, but there's really not that much at issue in terms of dollar value. And it also seems like if you could resolve this case, then the sisters could both go on about their lives and continue being estranged in a way that they're comfortable with.
Your Honor, I welcome you to order mediation. We did mediate with Matt Theory at Miles Mediation, and we were shocked that it didn't settle. And we would be happy to go back to mediation.
Well, I don't want to force mediation if a good faith effort's been made that failed, but I always welcome it. Mr. LaVorse?
Your Honor, I agree with Ms. Ross that we mediated. I can explain the essence of her shock. Her client back in February of 2021, February of 2022, when we mediated, started out the mediation demanding we pay her $100,000 in attorney's fees.
Mm.
And that kind of put a damper on the conciliatory aspect that might be explored in a mediation.
Okay, well,
Yeah.
I don't want to hear any more about mediation. I don't really want to know the ins and outs. I know Matt Theory. I used to, he and I litigated as co-defendants a case together for probably 2 years. So I know him pretty well, and I'm sure he did his dead level best to try and navigate the emotional baggage that goes with this kind of dispute.
Well, do I get to say then what Matt said about the case, since Alex is, Matt said, I can't.
No, I
believe-"
don't. I really don't.
Okay, I will. I'm sorry. I will.
Thank you. The internal dealings of the mediation should remain confidential.
Yeah, I agree.
And so we're going to leave it there. So what I will expect then is I will see you. If you are looking at a March calendar, then what that would likely mean is that you would be called in. I would probably say the first week of March for a pretrial conference. So I'm just warning you of that in advance. Now, that's not something that requires your client's attendance, although they're free to attend if they wish. And it's typically done by Zoom unless the parties insist that it be done in person. So I would expect that we would still go ahead with that with an eye toward that March calendar, Mr. LaVorse.
Okay. Your Honor, one other thing I'll remind the court of is I do have a leave of absence that runs through about February 23rd.
Okay.
We filed it probably mid-June or so.
Yeah, well, that wouldn't be a problem because I'm not going to call you in for trial before March. And the soonest I would call you in on a pretrial for a March trial would be that first week of March. And it might even be the second week of when it falls, depending on when it falls.
Okay, I understood there might be some motions or something that are due prior to the pretrial conference. Based on your standing order, that was my concern. Okay.
Well, so if I'm looking at my calendar, my guess is that the pretrial conference would be sometime the week of March the 6th. And so that would be basically a week in between your leave of absence and the pretrial conference. And that seems doable. Okay. That is Mr. LaVorse. Can you have those orders to me by the end of the week?
That's exactly what I was going to ask for, Your Honor. I can have that certainly drafts to Mr. Freehoff by that time. And of course, I'll copy Ms. Ross.
Okay, excellent.
Thank you.
Anything else, Ms. Ross, Mr. LaVorse?
No, thank you, Your Honor.
Okay.